So after having a classification of the unit first of the contract law, here I'm going to discuss with the contract law, the first lecture, which will cover the contract, the meaning of the contract, the definition of the contract, the nature of the contract, and further the essentials of a valid contract and the kinds of the offer. So these elements will be covered in the first lecture. So now I'm starting with the first element of my first lecture, that is what is the contract. So first of all, we should understand that what is a contract. So as per the statutory definition, means as per the Contract Act, section 2 clause H, means that means that a contract is an agreement that is enforceable by law. So it makes it very clear that before a contract is becoming a valid contract, it should be an agreement. So it's a very important thing which I would like to quote here, that a contract is a prima facie agreement, but each and every agreement needs not to be a contract. So here are the two examples. So take A and B. Suppose that illustration 1, A agrees to buy a house of B for an amount of 5 lakh rupees. Both are willing to perform own duties. Means A is willing to give a 5 lakh rupees, and B is willing to sell his house. So both parties are willing to perform its own obligations. Here is an agreement that yes, A will buy the house of B for 5 lakh rupees, and B will sell his house for 5 lakh rupees. Okay. So here is an agreement, and since this agreement is a valid agreement, so it will be a contract first. Now take the second example. Illustration 2, A invites B to his home for the party, but B fails to do so. Here yet exists a valid agreement, but it's not a contract. Why? See, there is a concept that the intention to create a legal relationship between the parties. It's not given in the Indian Contract Act especially, but the English law is following that concept. And I have dealt the intention to create a legal relationship in the further part of my lecture. So I'm just quoting here that one thing, that all the agreements are not necessary that they will turn into a contract. Meaning thereby that a contract is a per se agreement, but each and every agreement is not final that it will turn into a contract. And here these are the two illustrations. That's why it is said that an agreement which is enforceable by law, like illustration 1 says that A agrees to buy a house of B for 5 lakh rupees. B is willing to sell his house for 5 lakh rupees. This is an agreement, and this is enforceable by the law, because here the subject matter of the agreement is valid. Subject matter of the agreement is somehow that the law can enforce. But in the second illustration, where A invites B for the party and B agrees to attend the party, but subsequently he fails to do, the subject matter of the agreement, that is to attend the party, is not enforceable by the law. So that's why it is said that an agreement which is enforceable by law. Agreement. So for the first element, if we say identify the first element of a valid contract, then we will say that the agreement is the first element of a contract. So I'm now referring to the second element, and which will be identified by the Frederick Pollock definition. He states that a promise or set of promises which the law will enforce. So here, so as per the section 2H and the Frederick Pollock definition, the two elements are the common. Like, means one element is common, that is the law will enforce. Both definitions are saying that only those agreements which will be enforced by law will be contract, and Frederick Pollock is also saying that promises or the set of promises which is enforceable by law is a contract. So as I said earlier that here we are going to identify the second element. So the second element is this, that the promise. So promise is the second element. So how a promise is formed, I will discuss it further. Now I'm going through the some essential elements of a valid contract, as I have written that the Section 10 of the Contract Act 1872 states that there must be a existence of an agreement. As per the Section 2 Clause H, it also said that an agreement which is enforceable by law is a contract. So the agreement is the first element. Second, it should be accompanied by a free consent of the parties. So what is free consent? Free consent means suppose A and B आपस में कॉन्ट्रैक्ट में आना चाहते हैं, बट B is somehow suppressing A. Now, it's whenever if A will give his consent to the agreement, but this will not be a free consent. So for a proper contract, it should be a free consent of the parties. Otherwise, it will fall under the undue influence or the fraud or the misrepresentation. That's why I have provided the referring provisions like section 13, 14, 15, 16, 17, and 18. So these are the provisions which states that if a consent is due to these factors like fraud, undue influence, coercion, or the mistake or the misrepresentation, then that consent will not be treated as a free consent. And further, for a lawful consideration and with a lawful object. So contract should be for a lawful object and for a lawful consideration, meaning thereby that if suppose that A is saying to B that I will fix your job in Lucknow University, and if you are agreed to pay me 25 lakh rupees. So here the subject matter of the contract is not a valid. So it will not be treated as a lawful object, and it will also not be enforceable by the law. So here the referring provision is the section 23 of the Contract Act. So I'm just going to a quick revision of this element, that what is contract. So section 2 clause H states that every agreement is in contract. Every agreement which is enforceable by law is in contract. So each and every agreement which is not enforceable by law is not a contract. A contract per se is an agreement, but each and every agreement need not to be a contract. So here I have provided the illustration 1, which is supporting the section 2 clause H, and illustration 2 is also supporting that each and every agreement will not be a contract. Further, I have dealt with some referring provisions that how a valid contract can be made by the free consent of the parties, by the lawful object of the parties, and other elements of a valid contract. Now I am referring to the nature of a contract. So the nature of a contract is important. Why? Because the nature of contract will decide that whether it is enforceable by law or not. So if the classification is made on the basis of the essential elements, so it can be said that there are the two types of the contract. One is the void agreement and second is the voidable contract. So what is void agreement? Void agreement, as per the section 2 clause G of the Contract Act, it states that whenever, so when in the formation of the contract the below provided the essential are not present, and due to that it becomes unenforceable by law. So this is void agreement. So when an agreement which is not enforceable by law is called a void agreement. So what is the example of this? So the provisions of the Indian Contract Act from section 24 to 30 means 24, 25, 26, 27, 28, 29, and the 30 are the illustrative provisions and the examples of the void agreement. So here I am providing the example. See, as I told earlier, I provided the example earlier that suppose ए बी से कहता है कि मैं आपकी जॉब लखनऊ यूनिवर्सिटी में लगवा दूंगा एंड इसके लिए आप मुझे 25 लाख रुपीज़ पे करें. सो हियर this is an void agreement because the subject matter, because the object of the contract, object of the agreement is not a valid. That's why it is a void agreement. The second form, the second kind, the second nature of the contract, which I said, that is the voidable contract. It is a voidable contract because here the validity of the contract is depend upon the willingness of the one party. It's somehow tough, but I will make you understand very well that, for example, the consent provisions which I referred earlier, like section 13, 14, 15, 16, 17, and 18. So I'm just providing an example. See, suppose A wanted to sell his horse to B, and A knows that the horse is mad, but B doesn't know this fact. After selling the horse to B, B after 1 month or 2 months recovers that the horse is mad. Now the consent of means when because the offer, acceptance, consideration has been fulfilled. So it's now a contract. But the validity of the contract is now depend upon the willingness of B. If he wanted to validate the agreement, validate the contract of selling a mad horse to himself, he can say yes, okay, it's okay, it's fine, and I'm satisfied. So if he doesn't feel any if he doesn't feel any problem to have a mad horse, it will be a valid contract. But suppose he says that no, he will not possess this mad horse because I thought that you will provide me the sound horse and etc. So that's why I will not take this horse anymore. That time, the willingness of one party, means the consent of one party, makes a very huge matter for the law. And if B doesn't agree to possess that mad horse, it will be again invalidates the contract, and A has to return the money to B as well. So again, if I provide the second example, suppose A and B में एक एग्रीमेंट होता है एंड जिसमें A B को एक पेन देने की बात करता है कि एक मैं आपको पेन 5 रुपीज़ में आपको मैं सेल करूंगा. एंड ही सेड कि ये पेन आपका ब्लू ब्लैक दोनों तरीके से काम करेगा. बट जो बी जब उसको परचेज करता है एंड ही रिकवर्स दैट ये पेन तो सिर्फ ब्लू ही काम कर रहा है, ब्लैक काम नहीं कर रहा है, मतलब उसने मेरे साथ कुछ ना कुछ इसमें फ्रॉड किया है या जो उसने मेरी कंसेंट ली है उसने मेरे धोखे से ली है. तो हियर द ऑप्शन टू वैलिडेट द कॉन्ट्रैक्ट इज अपॉन द बी. If B would like to validate the contract, he will say yes, okay, it's fine, I will possess this pen. And if he would like to invalidate the contract, he can say that no, I will not possess this pen and return my money. Then in this manner, it will be a voidable contract. That's why it is said that a contract whose validity is depend upon the willingness of one party. If one party says yes, then it's okay. Otherwise, the contract will be void. The further form of the contract is divided upon its how it is formed. Like our contract is formed by 3 contractual obligations. One is the agreement, which we are reading right now. Second is the standard form of contract, and the third is the promissory estoppel. So, standard form of contract is what? Where the terms and conditions of a contract is prefixed by the offerer and is presented to the offeree to obtain his willingness. And the difference between the simple contract and the standard form of contract is that in the simple contract, in the ordinary contract, the offeree is free to have a negotiation, is free to have a discussion, is free to to decide that what terms and conditions are relevant or reasonable or appropriate or not. But here, in the standard form of contract, the offeree is not having any such authority to decide that whether this offer is valid, whether these terms and conditions are appropriate, whether this consideration is not reasonable. So here means whatever the offerer has presented to the offeree has to signify his assent in yes or no. He is not having any other option that to rectify or to discuss or to negotiate regarding the terms and conditions of the offer. That's why it is said the standard form of contract. So due to that, the high bargaining position of one party, the court has illustrated many provisions, means court has provided certain elements through the illustrations, through the interpretation, that these are the duties imposed upon the offerer, that before making an offer to the offeree, he would like to cover these elements, otherwise his offer will not be treated as a reasonable. So the examples are the LIC policy, the ticket, etc. So suppose in LIC policy, whenever if we are going to purchase a LIC policy from any SBI or from any other bank, whatever, so the form is presented to the us, means the offeree VR and offerer the LIC policy. Means LIC policy means the SBI or the other banks. Here we are having we are having the right to just signify own assent, whether to accept or to not, and not to, we are not having any right to negotiate with the terms and conditions that to provide the, suppose there is a condition that you have to provide the ID card photocopy, Aadhaar card photocopy, and I'm saying no, that this condition is not appropriate, I will not provide my ID card. So this is not provided in the standard form of contract, and that's why the court has dealt with the interpretation and provided that the offerer has to provide the certain elements, certain conditions before making an offer to the offeree. Otherwise, if he is not complying with these conditions or elements, his offer will not be treated as a valid offer. The further basis upon which a contract can be made is the promissory estoppel. The promissory estoppel is when one person makes a promise to other person that if you perform this act, I will do in response of that act. So the first person who has promised to perform in response to the first act, he said that he has made a promissory estoppel to the other person. Example, say A and B, the two persons. A says B that to perform certain act, and in response to that, I will do your work. Means I will write an essay for you. Suppose means A says to B that if you will perform this act, I will write an essay for you. So if B performs successfully the required act of A, now A is compelled to write an essay for the B. So the promissory estoppel is also dealt under the section 115 of the Indian Evidence Act. So this is the statutory provision that states that whenever a promise is made by the one person, and upon that faith of the promise, the other person has made certain acts, then the first person is bound to perform those promises. So now I'm going to deal with the other part of my lecture, that is the essentials of the valid contract. So just a quick revision. I deal with the nature of the contract, the void agreement, section 2, clause G, the voidable contracts, section 2I of the Contract Act, and the standard form of contract and the promissory estoppel. Now, essentials of the valid contract. So here is the one chart that states the essentials of a valid contract. First is the parties, second proposal, third acceptance, fourth one is the consideration, fifth one agreement, sixth competency of the parties, and the last one is the free consent of the parties. So in the first lecture we will do the second and the third element in a great detail, the proposal and its acceptance, and the other elements will be dealt in the further units of the contract law. So first element is the parties. So for a valid agreement, it is necessary that there must be a two parties. It's a very basic thing that if you are making an agreement, then there should be a two parties at a minimum level. Further, the important thing is this, the competency of the parties. So section 10 as states that whenever there is an agreement, it should be complied with the lawful object, lawful consideration, and competencies of the parties. So what is the competency of the parties? Competency of the parties is illustrated further by the section 11 and 12. Section 11 states that competency of parties means the age of parties. So in India, as we are having the age of the person who can enter into a contract is the age 18. And how the age will be decided is as per the Indian Majority Act 1875, which states that a person is major when he is of the age of 18 or above. Second, the competency of parties is also decided upon its soundness of mind. Soundness of mind is further illustrated or further defined clearly by section 12 of the Contract Act, and the competency of the parties will also be discussed in the further unit. So I'm just having a little light upon this element, that parties should be a major and parties should be of a sound mind. It should not be a minor, it should not be a unsoundness. The other essential element is the proposal. Now we are going to discuss the proposal and offer in a great detail, and here the first unit starts with the significant portion, that is the what is the offer and what is the proposal. So the section 2A states that proposal is made by one party indicating its willingness of doing or abstaining from doing something in order to seek the assent of the other party or the person. The party who makes the promise is called the offerer, and the party to whom the offer is made is called the offering. And the further is illustrated, the further is defined under section 2C, that states that the person who makes an offer is called the promiser, and the person to whom the promise is made is called the promisee. Means to whom the offer is made is called the promisee. So now I'm just providing an example that what is an offer. ऐसे general languages में we say that suppose that if I'm saying that would you like to buy my house, so this is an offer to you, that whether that are you agree, are you willing to buy my house or not. So illustration as I have provided, that A wants to sell his pen to B for 50 rupees, and for doing the same he has to communicate the same to the B. Otherwise how can A sell that pen to B, means otherwise obtaining his assent. So for this, whatever act A will perform to B, that will be said that he is making the offer to the B. So offer is made with the intention to obtain the assent of the other party. So if I am making an offer to you for selling my pen for rupees 50, so here is the intention of mine to obtain the assent of you. Otherwise, it will not be a valid offer. For a valid proposal, it is necessary that there should be intention to obtain the assent of the other party, and the subject matter of the offer should be valid. Suppose I am selling a pen, it's an lawful object. But if I am saying that I will fix your job in Lucknow University, it's not a lawful object. Now, I am going to discuss with the kinds of offer. So, what are the kinds of offer? It's also an important aspect of the contract law, that what are the kinds of the offer. First is the based upon its expression. Based upon its expressions, meaning thereby that how an offer is communicated to the offeree. So, Section 9 states very clearly that the offer can be made in two forms. One is the implied, and second one is the express offer. So, express offer meaning by simple that whenever an offer is made in words, whether written or spoken, it is said that it is in a express form. And when an offer is made otherwise in words, whether spoken or written, it is said it in an implied form. So, whatever the illustration I have provided earlier are the examples of the express form. Like, I am again providing the illustration. Suppose I want to sell my house to you, and this offer is communicated by me, whether in face-to-face conversation or through letter or through phone call. So it's a express offer, because here I am expressing my willingness to obtain your assent to my offer. And if you are agreeing, then it will be an agreement, and further it will be a contract also. So it's an express offer. What is an implied offer? So implied offer, as I said, that it is made when an offer is made otherwise in words, whether spoken or written, it is said to be a implied offer. So the implied offer, the examples are the auction and the tenders. So suppose in IPL seasons, Indian Premier League, which is due to coronavirus, has not been conducted yet now in 2020. But the basic elements of the auction of the players in the Indian Premier League. Suppose Chennai Super Kings buys the Dhoni. So how an auction is conducted? That suppose there are 5 participants in the auction process. A is saying 25 lakh, B is saying 50 lakh, C is saying 75, D is saying 1 lakh, 1 crore, and E is saying 1 crore 25 lakh. Suppose. Then here, if no one contradicts the last person's auction, that is the 1 crore 25 lakh made by B, then it will be deemed accepted. But how it will be deemed accepted? By the fall of the hammer or any other particular method which is used by the authority in conveying its acceptance. So, a bid at an auction, a bus service are the clear examples of the implied offer. So take a very flexible example of the bus service. Suppose we are traveling from Charbagh to Kaisarbagh. So we entered into a bus, and now when I entered into bus for the traveling purpose from Charbagh to Kaisarbagh, then it's a very implied that I have to buy a ticket from the bus conductor. So it's an implied offer from the bus conductor that you are required to buy the ticket. Otherwise, it's a punishable offense. That then you will be punished. Here are the 2 cases which I will deal to make it more feasible, to make it more understand that what is the implied offer. First is the Haji Muhammad Ishaq versus Muhammad Iqbal. Here the defendant supplied the goods to the plaintiff, and the plaintiff in turn partly paid the payment. but subsequently refused to make the payment. The plaintiff served several letters to him asking for the money, but the defendant doesn't reply any of the letters, but also doesn't contend that he is not going to make the payment. The matter went to the Supreme Court. The Supreme Court held that it is an implied offer that is validated by the conduct of the parties. Defendant, by his conduct, had accepted the offer and thus bound to pay the rest of the money. The conduct of the parties is shown by which, when the plaintiff sends a good to the defendant, and the defendant partly made the payment and also accepted the goods, it is sufficient that it means that the defendant is willing to pay the whole money and not only half or the quarter of the money. So that's why the Supreme Court decided that it's an implied offer and it is validated by the conduct of the parties. So now it's totally upon the so now the defendant is bound to pay the whole money to the plaintiff. Second case is the landmark case of the Contract Act regarding the implied offer, the Upton Rural District Council versus Powell. Here the defendant firm caught the fire, so he called the fire brigade for upon the belief that this survey is totally free of cost. So when the defendant called the fire brigade, the plaintiff came and and they also actually they worked upon the service and they provided the relief to the defendant. Subsequently, the plaintiff wanted to have a compensation from the defendant, that now you are required to make the payment, now you are required to make the compensation for the services which we have made earlier. Now the defendant refused, and he said that it was not an that means there was not a contract between you and me, so you can't enforce the contract. So it means that we are not liable to make the payment to you. The court held that on the demand of the defendant for the fire brigade service, it served upon that purpose, it served upon that belief by the plaintiff that he is entitled for the compensation further. That's why it is said that it's an implied offer for the defendant, and now the defendant is bound to make the payment to the plaintiff. Second classification of the offer is based upon the number of the offeree. Means when the number of the offeree as the offer is made by the offerer to the offeree, so when the number of the offeree is limited, it is said that it's a very specific offer. But when there is no certainty regarding the number of the person to whom the offer is made, it is called the general offer. So a specific offer, suppose I make an offer, so suppose I made an offer to you. It's a very specific offer because this offer is only for you, and if any third party accepts that offer, it's not enforceable against B. Suppose A makes an offer to B for selling his house for 50 rupees and B agrees to buy his house, or he doesn't agree to buy his house. So it's a very specific offer which is made to only B and not to any third person. Next one is the general offer. General offer is where the number of the offeree to whom the offer is made is not a limited one. So there is a very landmark case, Carlyle versus Carbolic Smoke Ball Company. This case will also be dealt further in the acceptance part. So here I have referred this case just to make understand you what is general offer. Here the defendant company makes an offer to the whole world that if anyone who takes the prescribed medicine of his company of influenza disease and if he takes the medicine as per the prescribed guidelines, he will never caught the influenza again. And if he caught the influenza, then the defendant company will pay the compensation to that person. So this offer is made not to a certain person, not to a specific person, rather it is made to the whole world. So it's open for any person to accept the offer. Upon this offer, one person accepted the offer by performing the conditions of the offer, that to buy the disease and also by taking the disease in the prescribed manner. So one person who has accepted the offer will only be said that he has entered into the contract between the defendant company, and not the other person who has just read the advertisement and ignored the advertisement. So I'm just emphasis upon this element, that why it is general offer, because it is open to anyone who would like to perform the conditions of the offer will be treated as the offeree of this offer, and also there will be a contract between the company and the person. And if that person who has bought the medicine and took the medicine as per the prescribed by the doctors, he will never caught the influenza. But if he caught the influenza again, the company will pay the damages. Is only enforceable with that person and not with any other person in the world. So it's a general offer, and specific offer is limited to the certain person. General offer is not limited to any certain person. Third one is the standing, open, or the continuing offer. So what is the standing, continuing, or the open offer? So when an offer is made by one person and is open for a certain duration of the time period, that anyone who is willing to accept the offer can do so within this time limit, will be treated as the acceptance of the offer, and there will be a valid contract between offerer and the offeree. Example is that A placed an offer that anyone who is willing to purchase the fruits can make an offer from 1st January 2020 to 31st December 2020. So P, if accepts the offer between this time period, means from 1st January to 31st December 2020, it will be deemed as a valid acceptance of the offer, and further it will be a contract between both the parties. So this is then continuing offer. Why it's a continuing offer? Because it is in continuance for a certain period, and anyone who is willing to accept that offer can accept the same. Now I am referring to the two cases. First case is the Bengal Coal Company versus Homi Wadia and Company. Here the defendant company agreed to supply the coal to the plaintiff for a period of 12 months. So whenever the order is made by the plaintiff, the defendant company complied with the same and also supplied the coal to the company. But before the 12 months, the defendant company withdraw the offer. Means further he will not supply any coal to the plaintiff company. The plaintiff filed a suit for the breach of the contract. The court held that there was a contract between plaintiff and defendant till the offer was not withdrawn by the defendant. But as soon as the offer has been withdrawn by the defendant, there is a no contract between both parties. It's a very landmark ruling that states that a continuing offer is valid only till the limit the offer is not withdrawn by the offerer. Means the principles of the general offer, means the revocation of offer, and acceptance, whatever means, and the other principles which will be discussed further in the lecture, means further in the part of the unit, will also applicable on the continuing offer. So means if suppose that Wadia and company has withdrawn the offer on 31st July 2020, and whatever the offer has been made before the 31st July 2020, it is an obligation upon the defendant to perform those obligations. But after the 31st July, there will be no obligation upon the Wadia and company to supply the coal further to the plaintiff. The second case is the Rajendra Kumar Verma versus State of Madhya Pradesh. Here, the respondent invited the tenders. So, in response to the same, the plaintiff submitted its tenders before the authority. But before the opening of the offer, means before the opening of the tender, it got withdrawn by the plaintiff Rajendra Kumar. Now the suit has been filed by the defendant that you can't withdraw the offer, and also the authority has suffered the loss due to your withdrawal. So you are also required to compensate the authority for the loss also. The court said that if your agreement has contained a provision like any person who has made a tender can't withdraw the offer at any time. So first of all, this clause is not an appropriate, because it's taking away the right of the person to take his offer or to decide the offer further before the acceptance of the offer. So here he is not bound to, means he is not liable to pay the compensation for the losses which you have incurred, because he has because he has withdrawn the offer in a lawful manner, and no such clauses in your agreement can bound to only make an offer and not to withdraw the offer before the acceptance. So in continuance of offer, means the continuing offer is something which is valid for a certain period of time, but before the certain period of time, it can also be withdrawn by the offerer. So whatever the offer has been made before that withdrawal, it will be complied by the person, and after that it will not be complied by the offerer. The first kinds of the offer is the cross offer. Cross offer is a very interesting kinds of offer, because here when one party makes an offer to the other person and without having any knowledge of the offer of the first person, the other party has also made the offer to the first person. So let's understand this concept in a very feasible manner. Suppose A and B, two persons. A is making an offer to B to sell his house for 25 lakh rupees. B, without having knowledge of the offer made by A to himself, also makes an offer to purchase the house of A for 25 lakh rupees. The both offers reach to, means B's offer reach to A, A's offer reach to B. Here, these offers are called the cross offers, and there is no agreement between, there is no acceptance, there is no contract between A and B unless and until it is accepted by any one party of the contract. So the example is the Tin versus Hoffman. Both the parties made an offer to each other on the same conditions and of the same subject matter, and without having knowledge of anyone's offer. Plaintiff initiated a suit for the breach of the contract committed by the defendant. The court held that since there was only offers between the parties, there is no exchange of the acceptance between the parties. So when there is no acceptance of the offer, how can it means that it's not a promise, further it's not a consideration, there is no such consideration, then that's why it's not an agreement. And so when there is no agreement between the parties, so how can it be a contract? And when there is no such contract between the parties, how can you file a suit for the breach of contract when there is only a offers between the parties and not any other acceptance of the offer? The other kinds of offer is the counter offer. Counter offer is interesting element and also very important kinds of offer. It occurs, suppose when offerer makes an offer to the offeree, and offeree tries to have a negotiation on the terms and conditions or on the consideration price or on the certain other elements of the offer. Now, whatever the letter or whatever the instrument is now made by the offeree to the offerer again, it will be treated as the counter offer and not the acceptance. Example is simple, that A made an offer to B that he is willing to sell his house for 50,000 rupees. In response to the same, B sends a letter that he is agreed to buy the house for 25,000 rupees. So it's a counter offer which is made by the B to the A. And if suppose that B says that, and if B files a suit in the court of law that he has now accepted the offer of A and A is not performing his conditions, he is not performing the obligation, it will not be enforced, because once a counter offer is made by the offeree, it is deemed that the original offer which was made earlier by the offerer to the offeree has now been revoked, and there has been a origin of the new or the original offer has been revoked and the new offer has been originated by the offeree by sending a counter offer to the offerer. So I'm just in this manner I have finished my first lecture, but now I'm just going to revise it in a quick manner. So first we did the contract, the meaning. So we did the section 2 clause H, that what is the contract. Then we did the elements of a contract, free consent, and I refer the provisions from section 13 to section 18. The lawful consideration and lawful object, section 23. The nature of contract means the void agreement, section 2G, and voidable contract, section 2I. This other forms of contract are the standard form of the contract and the promissory estoppel. Subsequently, I'll deal with the essential of the valid contract. So, in essentials of the valid contract, I dealt here the two elements, the parties and the proposal. Parties, here I referred the section 11 and 12, which will be also discussed in great detail in the second chapter, in the second unit of the contract law. Now, I have focused upon the proposal, that what is offer, what is proposal, and the definition of section 2A of the Indian Contract Act, and further the kinds of the offer. First, kinds of offer is based upon its expression. Then refer the section 9, implied offer and the express offer. Then the two cases, Haji Muhammad Ishaq versus Muhammad Iqbal and Upton Rural District Council versus Powell. These are the two examples of the implied offer. Further, I dealt with the based upon the number of offeree, the general offer or the specific offer. Here I dealt with the case of Carlyle versus Carbolic Smoke Pall Company case, and this case is also will deal in the acceptance portion of the lecture. Third type of offer is the standing, open or continuing offer, and here I deal with the again two cases, Bengal Coal Company versus Homi Wadia and Company and Rajendra Verma versus State of Madhya Pradesh. And the important thing in the standing offer or the continuing offer is that the general principles of the offer, like the revocation of offer and the communication of offer, is applied also in the standing or the continuing offer. Further, I dealt with the cross offer and the counter offer. Cross offer, Tin versus Hoffman, is the landmark case in the cross offer, and the counter offer, whenever the offer is made in response with respect to the negotiation of the terms and conditions by the offeree, it is said that it is not an acceptance of the offer, rather it will be deemed as the counter offer of the original offer. So by these elements, now I have finished the first lecture of the contract law, the first unit.